Welcome to the next edition of War Story Wednesdays. Today I want to talk about a couple of cases that are, or should be, near and dear to every broker's heart, especially if you are the designated broker of a corporate brokerage. The designated broker of a corporate brokerage. Companies can be licensed by the California Bureau of Real Estate, but there has to be a flesh and blood person that is responsible to the Cal BRE for anything that the corporate real estate brokerage does. Well, that makes sense, right? Because they need to be able to pick on somebody or get somebody on the phone. There were two different cases where the designated broker was sued on behalf of a customer of the brokerage. In one, it was an interracial couple that was attempting to get into some housing, and the agent within the brokerage refused to serve them, refused to present their proposals for purchase of the house. And they sued under the Federal Fair Housing Act. Now, they sued the designated broker as well, because under the Federal Fair Housing Act, the law says that anyone who has control over the entity that is engaging in the discrimination has liability. And, the couple said, the Department of Real Estate regulations in California say that the designated broker is responsible for oversight and supervision of all of the agents within the brokerage. The designated broker had nothing to do with the deal that the agent was involved with when the discriminatory act was undertaken. In fact, there wasn't any evidence that the couple had ever met the designated broker. And yet, the federal court found the designated broker liable. Well, he appealed. And the Ninth Circuit Court of Appeal agreed. And he appealed again, and the United States Supreme Court took that case and held that the designated broker was not responsible, even though the Federal Fair Housing Act said anyone who had control over someone who was discriminating would also have liability, and that there was a public policy to broaden the scope of who could have liability. The Supreme Court said that mere designation by a regulatory agency as the person in control wasn't sufficient. So they sent the case back to the district court, the federal district court, to see if there was any other kind of relationship between the broker, the designated broker, and the agent that could possibly give rise to control other than the mere regulatory oversight requirement. And the district court found that there was additional evidence of control and found the real estate broker responsible. What that control was this. The designated broker was really a rent-a-broker for all intents and purposes. He had owned the brokerage and he was selling the brokerage to the very agent that was doing the discriminatory practices and had pretty much abandoned the brokerage. He delegated all of the oversight responsibilities to this agent who then discriminated. And the district court said that under principal and agency law, which is different than the real estate agency law, that because the designated broker delegated the oversight responsibility to the agent, the designated broker could be held responsible for the improper action of the agent. That got every designated broker in California nervous. Fast forward a couple of years. In another case, this time in the California state system. There was an agent of a corporate brokerage who was working with a couple and helping them loan money, and arranged a loan by that couple to someone else that was doing a rehab of a piece of property. And the agent said that the $600,000 that was being lent would be enough to do the rehab work. And the property was going to be resold, everybody would be repaid, it would all be good. Turned out that the $600,000 was not enough. And one of the reasons it wasn't enough is that the agent took $300,000 of it and embezzled it. I guess that would hurt any kind of budget. The couple that had lent the $600,000 was unhappy, and they knew that the agent was broke. So they sued the designated broker, using this earlier federal court case as kind of a bootstrap argument as to why the broker would have responsibility. They made the same claim, that because the Cal BRE regulations require the designated broker to oversee the agents within the brokerage, that designated broker had responsibility to them, personal responsibility to them, for the losses that they suffered as a result of the agent. And the California Court of Appeals said no. While we appreciate the federal court's opinion with regard to whether or not a designated broker of a corporate brokerage would have responsibility for the act of an agent, that's not the way we interpret California law, and found that the broker had no personal liability to the customer of the brokerage. With regard to the federal case, the California Court of Appeals said while that's federal law, and while the Fair Housing Act may have a broader definition of control because it, the federal government, wants to impose as a matter of public policy stricter liability for enforcement of the Fair Housing Act. This wasn't a federal question, and it wasn't a question under the Fair Housing Act, this process of making the loans. Therefore, the corporate broker had no responsibility. That's a case that provides tremendous shelter for personal liability of a designated broker of a corporate brokerage. And it's one of the reasons why perhaps having a corporation as the brokerage isn't such a bad idea.